Hello, good morning, and welcome to today's webinar. This webinar is one in a series provided free to our clients and partners. It can be set against your continuous professional development requirements. It's being recorded and will be available to download from our website in due course. Our webinar today is going to be discussing intellectual property, how to protect it, how to commercialise it. My name is Mark Craig and I am Associate Director for the Company Secretariat Centre of Excellence here at Jordan's Vistra. I'm joined today by my colleague Declan Goodwin, who's Associate Director, Solicitor at Jordan's Corporate Law.
Hi, good morning everyone. Thanks for joining us.
Due to the number of attendees on the call today, and thank you very much for joining, you've all been put on mute for the duration of the webinar. However, it is designed to be an interactive event. I'd be grateful if you could email me with any questions throughout the session. If you look on screen just now, you see my email address at the top right, which is mark_craig@jordans.co.uk. So please email me throughout the course of this morning's event. Any questions we don't manage to get through today, we will answer by email after the event. Without any further delay or introduction, let's begin today's webinar. Over to you, Declan.
Great, thanks Mark. So today we're going to look at and run through the key aspects of a number of the most prevalent intellectual property rights, or IPRs, how they can be commercialised and exploited, some things to consider to put yourself in the best position when you're developing IP, and a quick look at IP enforcement and why it's important. And as Mark said, we'll finish off with questions at the end. So these are the key IPRs that we're going to look at today. There are a few others that aren't on this slide, but they're less common. So we're going to focus on these ones today. So before we launch into each one in turn, I thought it would be good to start off with to provide a basic understanding of the fact that there's two key types of IPR: unregistered and registered. So unregistered intellectual property rights are automatic rights. You don't have to apply for them, obviously, as the name suggests. There's sort of two key aspects to them. They're obviously a low cost option because they're automatic. You don't have to pay any fees to maintain them. But the drawback is that they tend to be harder to enforce if you need to. The benefits of a registered IP right would be obviously the fact they're easier to enforce. You can also apply in jurisdictions other than your current jurisdictions, so you can essentially future-proof your IP. So you can have a wider territorial protection based on the applications you make rather than the use you're making of the IP. So if you're looking to take over the world with your new business idea, that can be particularly useful. So next we'll just take a quick look at the symbols on the slide and what they mean. So the C with a circle around it signifies a copyright, and again there's no need to apply for anything to be able to use that. It's used as a marker to basically warn people that certain IP is protected by copyright and can't be copied without permission. The TM, that signifies an unregistered trademark, and the R with the circle signifies a registered trademark. It's quite common to use the TM as opposed to the R with the circle, even if you do have a registered trademark, because you might not have that registration in all the jurisdictions that you operate in. So it's often safer to go with the TM, and to be honest, the TM is more widely understood than the R. So we'll start with copyright. So what is copyright protection and what does it protect? It protects an expression of an idea, but not the idea itself. So, for example, you could have two mobile apps that perform the same function. So you might put into your app store a search for a calculator app. You'll get, possibly 100 different apps that could do that function, but they may have been developed independently using various different software codes. So copyright would protect the software code, but not the underlying idea that relates to. And in simple terms, copyright prevents anyone from copying that idea, but it doesn't prevent anyone from from copying that software code, but it doesn't prevent anyone from copying the idea. So it typically protects original artistic, musical, dramatic and literary works. So that's essentially anything in written form, any broadcast, movies, books, plays, even sculptures, choreography, poetry can all be protected. The duration of protection varies from country to country, although it is becoming more uniform given the international treaties that are in place. In the UK, copyright typically lasts for 70 years from the death of the author, or there are slight variations on that. For example, if the author is not identifiable, it would be 70 years from the date of publication or use. And then you've also got slight variations on that 70 years depending on what the actual copyright relates to. So you've also got sound recordings and broadcasts. So sound recordings 70 years, broadcast 50 years. So there's a few things that may pop up on your radar in the next few years. There's a number of famous copyright protected works that are going to lose their copyright. For example, in 1998, copyright was extended in the US for a further 20 years for works created prior to 1922. So one example would be, as of the 1st of January this year, there's a few Agatha Christie novels that are now unprotected. P.G. Wodehouse is another author that's now losing protection. From a sort of music point of view, George Gershwin's Rhapsody in Blue is now in the public domain and free of copyright. So over the next few years, a number of very famous copyright protected works are going to lose their protection. In 2024, copyright will expire for Steamboat Willie, which was Disney's first cartoon character, in theory. And then also things like Superman, Batman, Snow White, the Looney Tunes will all fall into the public domain in sort of 2031 to 2035. And I say in theory because corporations like Disney are obviously, they've got where they are because they're quite clever with their IP rights. It's quite likely that we'll see new uses of those old copyright protected works in the next few years, so that there's an argument that in their newest form they regain copyright. So one example would be the new Toy Story film that's going to be coming out soon. I've a young daughter and we've watched the trailer together, and that features one of her favorite characters, Snow White. So it's quite likely Disney will bring all these old characters into the present day to try and extend protection. One UK example, and it really emphasizes the fact that copyright arises based on law, based on statute, rather than an application. So in I think it was 87 or 88, former Prime Minister Lord Callaghan introduced an amendment to our Copyright Designs and Patents Act, giving Great Ormond Street Hospital a unique right to royalties from Peter Pan in perpetuity. So they will benefit from royalties from any use of Peter Pan in the UK.
I was going to say, yeah.
For forever, effectively, as the author kindly assigned those rights to the hospital. So, for example, if a new Peter Pan film comes out, royalties wouldn't be payable for use in maybe the US, but they would be payable for use in the UK. So from a UK sense, Peter Pan really is the boy that never grows up. So moving on to trademarks. So a trademark is a protection of a sign or a symbol used by a trader, so used in commerce to distinguish the products or services of that trader from those of other traders. It can be a brand, you can protect the brand, the logo, the style of your product, its packaging, the shape of a product. The example on the slide is the shape of a Coca-Cola bottle. Colours and sounds and smells and slogans can also be protected, but it's extremely hard to be granted a trademark for those and to maintain it. So some examples of that are the purple of a Cadbury's dairy milk, BP's green colour. They're all trademarks that have been tested through the courts, and quite often they've failed to receive protection following that court action, but in theory it is possible. In the UK, you could apply for a UK trademark, or as we are still within the EU, you can also apply for an EU trademark. Once we leave the EU, you can still apply for an EU trademark. We won't be prevented from doing that simply because we're not part of the EU. And what an EU trademark does that a UK trademark doesn't do is provide protection throughout all of the EU's member states. EU trademarks were known as CTMs, or community trademarks, prior to 2016. So if your business has a more international angle and trades outside of the UK and has reputation outside of the UK, it can often be very beneficial to apply for an EU trademark as opposed to a UK trademark. So you're effectively making one application for protection in a number of territories, which is also, it's obviously more efficient and cost effective. Both registrations last for 10 years and are then renewable for further 10-year periods. So in order to be registerable, a trademark needs to be capable of being presented graphically. So essentially you need to be able to depict the trademark on your application form. It needs to be distinctive, so it can't be too similar to anyone else's trademark. And it needs to be capable of distinguishing goods or services. The final requirement is it can't be excluded by statute, so that might be something maybe immoral or offensive. You couldn't trademark, or you would seriously struggle to trademark any brand name that used a swear word, for example. So moving on to design rights. Design rights protect the appearance of all or part of a product. So think of Trunky products, Dyson products, Apple, or Maglite. They're all distinctive, and as soon as you see a product from one of those companies, you almost certainly know which company is behind that product. Again, like trademarks, you can have unregistered design rights and registered design rights. And the same as trademarks, an unregistered design is automatic and potentially harder to enforce. A registered design needs to be novel, so new. It can't copy any or rehash anything prior to that design. It needs to have individual character and not be excluded by statute. The protection can last for a maximum of 25 years and needs to be renewed every 5 years. Again, you can have protection at both UK and EU level. The EU rights tend to be broader in scope, but can only last for 3 years. The UK, as I said earlier, the UK right can last for 10 years, and that's 10 years from when that product is first marketed. Design registration is relatively low cost, and it's particularly appropriate for industries like the fashion industry, where designs are instrumental in selling the products. So the shape of your Levi's jeans might be protected by design right. And obviously that's also an industry that suffers heavily from counterfeiting. So fashion companies do tend to really rely on design rights and do enforce them where possible. So moving on to patents. Patents provide inventors with a monopoly over their inventions, and they protect the new and technically innovative features of those products and processes. So the new invention must be new. Obviously, you can't protect something that's come before it. It needs to involve an inventive step. So it needs to involve something that no other person has thought of, or a process that no one has ever thought of doing before to achieve the result. It needs to be capable of industrial application. So, for example, that would potentially prevent you from applying for a patent for a teleportation device that you might see off Star Trek. And again, it needs to not be specifically excluded from protection. So there are certain types of product that are excluded from protection for the benefit of society. So things like pesticides are often included in that one, because obviously there's very wide benefit to society in being able to grow crops and food and good stuff like that. It's also very difficult, particularly outside of the US, to patent computer programs or software, methods of doing business, and methods of medical treatment. So if a surgeon comes up with a new procedure for complex surgery, they would struggle to patent that as a process. And that's in stark contrast to the pharmaceutical industry, which relies heavily on patenting the drugs that they research and develop and produce. Mentioned at the start of this slide that you gain a monopoly through your patent, and that lasts for 20 years in most countries. Again, the pharmaceutical industry has the benefit of an additional, or they can apply for an additional 5 years of protection via an SPC, and that is because that's what recognises the fact that it takes so long to research and bring to market a new drug.
And that's why they can protect it regardless of it being a public benefit.
Yes,
Yeah.
I mean, given the cost involved of developing drugs, and this goes for most IP rights, there's obviously an investment that needs to be made, and if there was no ability to recoup that investment, then those sort of new drugs wouldn't be developed.
Yeah.
So yeah, there's a balance to be struck there, and I think that balance comes through the fact that the monopoly is limited to 20 or 25 years potentially, following which time the cost of those drugs would usually come down, and yeah, society may see more of a benefit. So the picture on the slide shows one of the more interesting patents for all.
Is that Twister?
It is Twister, yes. So the Milton Bradley company managed to get a US patent for something titled as the apparatus for playing a game where players constitute the game pieces. So effectively, rather than having a small plastic object or a small metal object, they've managed to patent the process here of introducing human beings as the playing pieces in a game.
Not quite an industrial application.
Well, industrial, yes, that can be sort of stretched.
Commercial, perhaps.
Commercial, yes, and in effect, that is what it means. You have to actually be able to produce whatever's being patented. It can't merely be something you've dreamed up,
Okay.
or something where the technology isn't available to actually produce that patented object or process. So yes, that example was patented in 1969 when that concept would have been new and inventive. If you tried to patent something similar today, you'd obviously struggle. So we've covered the key IPRs. We're now going to move on to looking at how they can be commercialized. And we've got two organizations that I think emphasize or are good sort of mini case studies at emphasizing a successful commercialization of IP. So starting off with Disney, as I mentioned earlier, they've managed to derive value from all of their IP to the fullest extent. So they've got their core business, which is producing content, so films, TV shows, cartoons, and then they've managed to use that core business to produce a variety of other products and services. We've also got Trump. So he's started off in the property industry, and he's also seen the value of brand Trump. Both companies have produced clothing, believe it or not. You can buy a Donald Trump shirt. Both companies have restaurants, both have golf resorts, hotels, both have TV shows. Donald Trump was Alan Sugar's equivalent in the US. They've both got ice rinks in a sense, or in fact, Disney used to own an ice hockey team. They don't anymore. Both have their own brands of water, and both have perfumes. You can buy Disney Princess perfume, and you can buy Trump perfume.
Goodness.
Which thankfully doesn't smell like the name, but they're actually named Empire. Any ideas what the second
Empire.
might be?
Gosh, I don't know. Imperial.
Success. And yeah, so after conquering the world with all, exploiting his brand in all its various various aspects, there was only one thing left to do, and that was to take over America and make America great again. So
imagine Walt Disney as US president.
imagine, yeah. So Disney have taken another tack. They've gone on to conquer the world of comic book characters and sort of dip their toe into science fiction. They've swallowed up the likes of Marvel and Star Wars, and they've used their recipe for success in those areas as well. So there are a number of different routes for commercializing your IP. We've got DIY, do it yourself, buying IP or selling your IP, and then partnerships. So entering into partnerships via licenses or a franchise arrangement, joint ventures or spin-outs. And if you're maybe a startup considering how to commercialize your IP, there's generally it's generally based on sort of 4 key factors. I would say is choosing your sort of business route to commercialization. Your lifestyle is going to have an impact, your ambition, your business plan, capability and resources all have an impact on which commercialization route might be best for you. We'll take a look at some successful companies or businesses that have used each one of these in turn. So do it yourself. First we've got Nike. So they started out as a distributor of another brand's running shoes, that was Asics and Onitsuka Tiger, so Japanese companies. 1964 they were known as Blue Ribbon Sports, and as I said, they were distributors rather than manufacturers. In 1971 they changed their name to Nike and started developing their own shoes. So that would involve a design phase, development, manufacture, marketing and selling. It's quite a lot to do. So there's an emphasis on hard work, resource, time. So that's the sort of the hard part, but the benefit there would be potentially larger rewards and full control and ownership of your IP. Next, we've got an example of assigning or acquiring intellectual property. Here we've got the fashion or retail industry. We've got 2 clothing brands at different ends of the spectrum. We've got Donné, who I think originated as a tennis sports brand and then sort of more of a general sports brand at the lower end of this cost spectrum. And we've got French Connection, which is a sort of higher end fashion retail brand. We've got one person who is relevant to both brands, and that is UK retail magnate Mike Ashley. He's renowned for essentially acquiring potentially distressed retail brands and turning them around and making a large profit essentially from maximizing the brand that company or either Donné or French Connection have. So the aspects to consider here are, particularly if you're looking to exploit distressed brands, lower upfront costs in terms of you're not required to develop those brands over a long period of time and invest a lot in marketing those brands. They're existing brands that you can acquire for a cost, but if they are distressed, then that cost will potentially be lower. And then you can, if you've got the resource and capability, turn them around relatively quickly and look to drive a profit.
There's a couple of companies, aren't there, with those very different brand models. So obviously, looking at Mike Ashley there with one end and the other end of the spectrum, but I'm thinking of Unilever as an example. So they've got a variety of brands from Ben and Jerry's to Dove soap. I mean, not necessarily either ends of spectrums, but very different in their operation or
Yeah,
their
it's
or
a
the distribution
really,
chain or anything else.
really good example, Unilever. So, and that's this sort of business model is very prevalent in the fast-moving consumer goods sector. I think companies often realise that they can only take certain brands or operations so far. Once they get popular enough, they do tend to be purchased by the likes of Unilever, who have strength in mass producing products, but crucially in their distribution and sale to maybe supermarkets and other sorts of similar retail operations.
Customer might be the same in those cases. Yeah.
So next we've got license, and again we've got one of my favourites, Disney and Mickey Mouse. So 1928, Steamboat Willie was created and released. That there's obviously not much money to be made in exploiting that film anymore, but the characters in it have become immensely popular. So they've gone on, as I said earlier, to exploit their characters in weird and wonderful ways. So the example we've got here is a t-shirt that you can buy on asos.com. With it's modelled by a trendy hipster, so quite a different market to the one that would have been originally thought of when that character was created. So the few things to consider with a licensing approach would be maybe you're extremely good at your core market, but you're very good at making films, but you're not so good at making t-shirts or other products. You might want to enter into a license to try and derive that extra couple of percent out of your IP in terms of turnover, but you can allow a company who's better placed to produce that weird and wonderful offshoot product. So you can provide them with a license to do that. A few things to bear in mind is to sort of quite accurately define the scope of a license to make sure they can only exploit your IP in the way that's intended. And enforcement and brand protection is obviously very important as well. So the things to consider here are you've got lower potential returns than perhaps the DIY route, but that's opposed to no return at all or high setup costs if you wanted to go into exploiting your IP in different markets. So as I said, Disney have done this with Star Wars now, and Star Wars have got branded products for everything under the sun. You can either get a Darth Vader toast machine, which I'm not sure if that's a great example because the toast doesn't look particularly appetizing. It looks great, but I'm sure the burnt bits wouldn't taste
Darth Vader toast.
But there's obviously a market out there for it, or they wouldn't have produced it.
Explains my niece's Star Wars t-shirt where she's got Mickey Mouse with a lightsaber, which I didn't quite understand.
Exactly, yeah. So that is an example of I think Disney widening their market for Star Wars products. You know, it's quite hard to sell scary looking aliens to 5-year-olds. So they've obviously worked out a way of selling Star Wars to the younger audience. Another model to consider here is open source from a software point of view. So open source software, that's where you make it very easy for people to use your software. and usually at zero or very, very low cost. And that creates a market very quickly for maybe ancillary services, and that might be consultancy services that you can offer to people using that open source software, or further software development where you can build on and use that software. And obviously one of the key benefits to open source software is rapid uptake. It's also seeing a really important benefit from a security point of view. So the more widely used that software is, the more likely it is for bugs and issues to be picked up and corrected. Next, we've got franchise. So this is a further development on the license approach. So if you've got a very strong product and proven business model that is rich in IP, franchising might be a good option in terms of expanding quickly, getting the most out of the valuable IP that you've built up. You might be held back due to setup costs if it's costly to expand. So here we've got the example of McDonald's or fast food industry. Property costs often hold back businesses in this industry, and that's why they tend to be franchised. So the franchisee would be responsible for property and finding a property and paying for that, and then the franchisor, which would be McDonald's in this case, licenses the franchisee to use their brand, use their recipes, use their products and marketing to essentially benefit from a proven product and business model. So the value here is a royalty fee for using the brand, a guaranteed supply of products and services, and then it's also quite common to charge a marketing fee to franchisees as well.
That reminds me of Starbucks when they first came to the UK, and I think it might be more than 15 years ago or so. And I think they've moved their model now to a more mixed, so they've got some franchise, so I think a lot of franchise and some owned or mortgaged property. But at the time when they came originally, they were described as a property company that sold coffees. Their balance sheet really resembled a property investment company rather than a coffee company, such as the amount of capital they tied up in property. And obviously that perhaps was an initial move which changed as they grew. But it's kind of interesting to note that franchise is a way of obviously getting much more growth quickly at low capital.
Yeah, exactly. You've hit the nail on the head there, and as I said, fast food and sort of food related businesses do tend to go down this franchise route, and perhaps the expansion of Starbucks nicely coincided with the growth in property prices. So
Yeah.
that might have played an impact in them
In
choosing
decisions, yeah.
to do that. But I think, the world we live in now, I'd find it, unless you're very capital rich, it would be difficult to sort of follow the same sort of path. Next, we've got joint ventures, and the example we've got here is Virgin Trains. So it's one of the UK's largest rail operators. So usually with a joint venture, you've got a scenario where two companies have got different skill sets or capabilities, and they join together to achieve a common goal. So in the example of Virgin Trains, we've got Richard Branson and his Virgin Empire and brand. So there's a good brand there, very good goodwill, and Virgin are typically known for high levels of customer service, which is obviously something that can be lacking in the rail industry. We've got their sort of joint venture partner in Virgin Trains is Stagecoach, which is a very experienced rail and bus operator, and they obviously bring the industry expertise required for operating a rail company in the UK. So the aspects to consider here with a joint venture, and I think in this case the joint venture is it's actually 51% Virgin and 49% Stagecoach. So you obviously give up a degree of control when you've got a joint venture, and also give up autonomy. You obviously need to involve your partner in decision making, but that has to be weighed up against the fact that Virgin would seriously struggle to operate a rail company without the expertise of Stagecoach. So you're giving away control in order to benefit from an opportunity. And then finally, we've got spin-outs. So you might have a large company or typically a university that is heavily involved in research and development and produces a lot of valuable intellectual property. That intellectual property, or the exploitation of that intellectual property, is not necessarily that company's core business. And so the IP is spun out into a newly established company, and people are appointed. Either that IP is purchased, or the university or large company retains a stake in the spun out company. This is really prevalent in the university sector. As I said, they're heavily involved in research and development, but quite commonly, due to the constitutions of universities, they're required to have an education aspect in a lot of the things they do, and commercial exploitation of IP on a large scale can sometimes fall outside of that. So it's almost a requirement that they spin out really valuable IP on occasion. So on this slide, we've got applied graphene materials, so very high-tech stuff. It was developed and spun out. It was developed in Durham University and spun out in 2010. IP Group invested in the spin out. It's a large IP-rich investment company, and by 2013 they listed on AIM, and this is often looked at as one of the most successful UK spin outs, or presently anyway. Another example of a commercial organisation that often does this sort of thing would be the likes of Hewlett-Packard or IBM. So they're heavily involved in research and development, but the IP that they create might not be something that the company wants to focus on exploiting, but there may be employees or investors that are interested in doing so. So that ends the look at commercialization. So we're now going to look at a few tips for when you're developing IP and a few things to think about. So before you develop your IP, it's important to prepare in advance. So the first thing to consider is confidentiality. You need to make sure that anyone involved in your IP development and that project is bound by confidentiality clauses or non-disclosure agreements. So that might be from an employee point of view, or that might be from a consultant point of view or partner point of view. Either way, it's important to ensure you've got agreements in place. Second thing to think about in those agreements is security of ownership. So you want to protect any IP leakage. So the default position and this goes for confidentiality as well. There is obviously a default obligation to keep things confidential, but you're in a much stronger position if you've got something written down that's easily referenced and easier to enforce in the form of an agreement. Same goes for IP ownership. With employees, the default position would be that the employer owns the IP created by the employee, but it's a lot safer to have that written into employment contracts. You can often get messy scenarios where employees create IP maybe in their own time outside of 9 to 5, but it could be done using information they've gleaned from working in that business, or maybe they've used a company laptop to help create that IP. So those sort of grey areas can be clarified via your employment contract. With any third parties, maybe you might engage a software developer or a consultant to assist you. There's no automatic assignment of IP when you're engaging those parties. So it's very important to clarify whether there's an assignment of IP from those parties so that you own the IP, or whether they're licensing it to you.
It's just about having very clear contracts of engagement, is that right?
Yeah, exactly.
For employment or for third parties. Yeah,
exactly. And if your business really takes off and you're relying on the IP that's been developed by these third parties and even employees, when it comes to an investment round, this is the first thing that people will look at. They'll need to understand and make sure that the IP you've created and rely on is properly owned and you have the rights to that IP. Another thing to consider during the development of IP is how it's documented. So particularly with the unregistered rights, it's very important to document IP ownership so that you can prove exactly when and how the IP was created. You're not relying on a registration, so you need to have some form of documentation that can evidence that. So record the creation of IP, including dates. And then once the IP is developed, as long as it's protected by confidentiality, and particularly in the sense with regards to patents, as long as it's not out in the public domain, you can then consider registration. Wherever possible, I'd certainly recommend using external expertise to evaluate whether your IP is capable of registration and evaluating IP strategies. So in terms of how, when and where you apply for registrations. So that would be a patent attorney, a trademark attorney, intellectual property lawyers or litigators. So finally, it's very important to consider enforcement of IP. So registration and protection is obviously very important as a starting point, but if you're not going to enforce your IP, and if you don't have the ability or resource to enforce it, it's you can question, is it worth having in the first place? It can be a deterrent to show that you own certain IP, but if someone calls your bluff, you are going to have to invest in enforcing it, and if you don't, you can lose your protection. And intellectual property is a valuable asset. It needs investment on a continuing basis, and that includes from an enforcement perspective.
There's no point in having it if you're not going to protect it, ultimately, isn't it?
Yeah, exactly. And unfortunately, if it comes to litigation, it can be an expensive process. Over the last decade or more, we've had the intellectual property court, which has been introduced in the UK, with the idea of speeding up IP litigation, and also making sure it's dealt with by IP specialist judges, and obviously improving the speed and ensuring that specialism makes the litigation more efficient and therefore cheaper. But even so, it's still, we're still talking in the sort of tens of thousands of minimum, typically for sort of court proceedings. Some examples of not enforcing your IP and therefore losing protection. We've got the trademark for Hoover. Lots of people now use that as a generic term. It's obviously it's a US white goods manufacturer. Hoover. They also might make other things like washing machines, but Hoover have lost their trademark because everyone calls a vacuum cleaner a Hoover.
Dyson Hoover. That's kind of oxymoron, isn't it?
Yeah, you'd have. I think you'd have people at Dyson jumping up and down if they heard you say that. Another one would be Google. So in theory, you've got everyone uses the term "let's Google it" rather than "let's use a search engine to search for something." It's not as catchy or quick. So with that example, though, it's not always bad. It's not always a bad thing to allow your term to become generic. It's often seen as a drawback, but I think allowing that term to become generic has, in part, helped Google achieve a monopoly there. It's so commonplace in our daily lives now.
Okay. Thank you very much, Declan. We appreciate your time this morning. We're going to open up for questions. As you can see on the screen, my email address is in the middle there, so it's mark_craig@jordans.co.uk. If you have any questions now, please send them across. Any we don't get to answer in this session, we can gather up and respond to you thereafter. We've got a question come through. Maybe slightly technical, but I'm trying to paraphrase it, I think, here. So if we're to restructure our group, how easy is it to move a brand between entities, so to a different legal entity than the one that is currently assigned, the brand is assigned to, or intellectual property is assigned to? Any thoughts on that, Declan?
Yeah, sure. So in terms of a brand, that's going to be mostly trademarks. So we need to consider whether they were registered or unregistered. In the case of unregistered trademarks, it would be a case of drawing up an assignment and assigning the trademark and associated rights relating to that brand to the different legal entity.
Yeah. It's pretty feasible to move it between entities then.
Yeah, absolutely. Yeah. With a registered trademark, you would do the same thing, but then there'd also be the need to update the registries as well with notification of the new owner. So that can often involve registering a copy of the assignment together with filling in a form produced by the registries. Lots of companies tend to opt for using a recorder rather than filing a copy of the actual assignment. So you're allowed, rather than file the assignment, which might contain some commercial information, so there might be a value assigned attached to that assignment. You could also draft a recordal, which essentially records the very basic details of the assignment, leaving out any commercial information. And so rather than including or sending a copy of the assignment to the public register, you could use a recordal. One other thing to consider here is typically with a group restructure, it's usually done for financial reasons or tax reasons, and it plays a big part in that. You can assign value to IP, and it can be very beneficial to make sure your IP is held in
the right entity,
in the right entity, in the right jurisdiction.
Yeah. Okay, we're going to wrap it up at 11 o'clock because I know everyone's got time pressures, but we have time for some more questions, so do keep them coming. mark_craig@jordans.co.uk. Again, I'll paraphrase this one. Why would a company go for an unregistered trademark over a registered trademark? And I guess there's a comment about, is it just costs? Is there cost differences between an unregistered trademark and a registered trademark, Declan? I think you may have covered that slightly, but maybe just reiterate.
Yeah, sure. So from a cost perspective, when you're applying for a trademark, there's typically a default fee, and then depending, you can apply to have the trademark registered in a number of classes. So they relate to how the trademark is going to be used. The more classes you register the trademark in, the more the fees will go up.
Yeah.
So for your typical trademark registration, off the top of my head, you're probably looking at something in the region of £500 or £600 for the registration fees. Obviously, the more classes you add to that registration, the more it's going to cost.
Mm-hmm. Another one come through. I think there's some concerns about costs here. So if I have to defend my trademark, would there be costs? So yeah, I guess there's a concern about the cost of a trademark. I guess it's ultimately, as we pointed out, you pointed out, I think the slide before, that if you're going to have a trademark, you may as well defend it, and therefore I guess it's this point about what are the sort of kind of estimated costs for defending someone utilizing your trademark? Is that maybe the question?
Yeah, I think we touched on this. So it is to answer the question, there would certainly be a cost, and it's the same as any litigation, really. There's often an analysis to be made in terms of if you're defending a claim or bringing a claim, if you're bringing a claim, you have to be prepared to see it through, really, and that can be very costly. If you're defending a claim, there's a cost analysis to be made in terms of do I try and settle, and agree a settlement figure rather than spend the money on legal fees and defending the claim and court fees. The other thing to bear in mind is with any sort of settlement, it is possible to enter into an agreement which would enable both parties to clearly identify what they can and can't do going forward. So it's not a sort of, it doesn't have to be a winner takes all scenario. You could agree the parameters for continued use, but they may be narrower than what you previously had.
Okay. Thank you, Declan. Thank you everyone for joining us today. I'm going to wrap it up. So we've got respecting everyone's time. I genuinely hope you found it useful. I think we both do. Any questions we don't get round to getting answered on the session, we're going to address by email. We've made a recording of today's webinar and it'll be available to listen again from our website. So if you or your colleagues want to listen again, you can do so. Do keep an eye out on the page there. You can see as well the URL for future webinars. Until next time, thank you and goodbye.